Resolution number 21-713, in the matter of reconvening the final hearing to address the Riboff number 620 watershed drainage improvement petition project.
So moved.
Second.
Motion made and seconded. Discussion. Vote.
Vote on motion 21-713. Mrs. Lewis?
Aye.
Mr. Merrill?
Aye.
Mr. Bitton?
Aye.
Resolution number 21-714, in the matter of approving for a specific occurrence a suspension of Rule 3 speaker registration, Rule 4 limitations, and Rule 7 public comment procedure from the rules governing public comment before the Board of County Commissioners of Delaware County, Ohio.
So moved.
Second.
Motion made and seconded. Discussion. Vote.
Vote on motion 21-714. Mr. Merrill?
Aye.
Mrs. Lewis?
Aye.
Mr. Bitton?
Aye.
Good. Still morning. Good morning, everyone. This is a continuation of the hearing that we had on June 14th. Just for the benefit of everybody here, I'm going to kind of read a little summary so we're all kind of have the same reminder of the information, and then I will do a couple other things and we'll begin. Previously on June 14th, the County Engineer and Soil and Water Conservation District cover report on the project. Landowner testimony occurred in person and in writing. The board heard information on claims for damages. The county engineer presented responses to claims for damages. The board accepted for consideration and allowed the claim from the Rices. The board accepted for consideration the Borgal, I hope I pronounced that correctly, Borgal? You did. Claim from December 2nd, 2020. And the board continued the hearing during discussion on the Borgal claim in order for the staff attorney to review that information. Our staff attorney is going to come up shortly, but before I do that, just kind of how we were going to proceed today. This is a continuation of the final hearing for the consideration of the Riboff number 620 watershed drainage improvement petition project. There's a sign-in sheet available. We ask that you please sign in. There are also copies of the map available. Previously, as I've kind of already summarized, the County Engineer and Soil and Water Conservation Districts covered a report on the project. Testimony occurred. The board heard information on claims for damages, and we continued the hearing. After listening to the testimony, after listening to today's testimony, and the board may decide whether to find in favor of the improvement, affirming the order, confirming the maintenance assessments, and approve the payment schedule, or the board may dismiss the petition by setting aside the order. As we stated before, the board considers the following in their decision: whether the board hereby finds that the proposed improvements is necessary, that it will be conducive to the public welfare. The board also finds that it is reasonably certain that the cost of the proposed improvements will be less than the benefits. Due to the board allowing a previous claim, if the board decided in favor of the improvements, this hearing would have to be continued so those assessments could be recalculated. The cost of any allowed claims is distributed to all the landowners in the watershed. And with that, I believe, Eric, I think you're going to come forward and give us, or maybe you're going to do it from there.
Yeah, I'll do it from here if that's okay. I did, after the last hearing, review all of the records from the 1947 and 1948 proceedings on this particular improvement. And the law in effect at the time did not require the establishment of an express easement during that process. So when I reviewed the records, there was nothing to indicate what the boundaries of an easement would be, because that was not a part of the proceedings under the law in effect at the time. However, the law in effect at the time and still in effect today in regards to when an improvement is constructed pursuant to this provision in the statute, that after 7 years, the improvement does become a public water course. So my opinion is that there is a prescriptive easement by operation of law over this improvement, but the width of that easement, the only thing that I can provide in any concrete terms is that it is following the definition of the public water course, which is bank to bank. Now, if the engineer or anybody else has information to establish, similar to when we have prescriptive easements for roadway purposes, where there has never been any express easement document, that The bounds of the physical roadway are not the extent of the prescriptive easement because there is the necessity for additional width for the purposes of maintaining that improvement. The same would be true for a public water course, that it is most definitely from bank to bank because that's the statutory definition. But it could be wider than that. I cannot provide you an opinion on whether it's wider than bank to bank. So if you have any questions about that, I'd be happy to answer them.
Questions? Commissioner Lewis, Commissioner Brennan? So if I try to summarize, basically, this claim has some merit.
The permanent easement and the temporary construction easements go beyond the banks of the existing improvement. And so to the extent of whatever that width might be, the claim should be considered in terms of compensation. Absent some information that's presented that the width of that prescriptive easement is actually wider than the width of the existing improvement.
Is there anything soil and water or the engineer's office want to add to this for clarification purposes?
Good morning, Rob Riley, Chief Deputy Engineer. We have spoken with Mr. Hostetler in this regard.
Sorry?
No, he asked if he should be sworn in.
If he's providing testimony,
Did you say yes or no?
if he's providing
Are you
testimony,
Yeah.
Well, we'll do that then.
Yes, sir.
Do you raise your right hand? Do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Proceed.
Again, Rob Riley, Chief Deputy Engineer with the Delaware County Engineer's Office. The prescriptive easement, Mr. Hostetler mentioned, generally the engineer's office is in concurrence with that opinion that there is a public easement of some width, some undefined width, along the course of the 1948 project. We further are of the opinion that there is a prescriptive easement of some width along each bank of the existing improvement because, and the reason we have that opinion is it's highly unlikely that the Board of Commissioners at that time or even the legislature authorizing the creation of petition projects would have contemplated simply building a ditch and then not allowing it to be maintained. Even though there was no express requirement that it be publicly maintained, it's very unlikely or very difficult to imagine that a board would have simply built, in using the road analogy, basically building a pavement with no ditches, no ability to maintain anything beyond the pavement edges. And so it is our opinion there is a easement along that existing corridor. The width we have not determined yet, and so if, with respect to the damage claim before you, if it is your intention to consider awarding all or part of that, we would need to go back and basically ascertain which portions of the proposed or requested damages are within what we feel would be an appropriate width of that easement. So again, that is our opinion. There is, I think, general concurrence that by virtue of this being a petition project in 1948, there is certainly a public purpose for this project. And so I think the matter before all of us is determining what is the width. I would add the proposed project does substantially follow the exact same course and alignment of the existing ditch. I would defer to Mr. Stevens for anything further on that, and if you'd like him to speak on that, maybe he'd be willing to do that.
Okay. Thank you, Rob. Any questions, Rob? Just a
Thank
second.
you.
Scott, do you have anything you want to add? No? Yes, you would.
Permission to rebut?
Come forward. Swear you in.
I was already sworn, but we'll do it again.
Do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Proceed.
Thank you. One of the documents that was placed in front of you this morning is a 5-page document which I created. My name is Rich Bergalt. I own the property at 9032 Todd Street Road. My wife is sitting here with me. The engineer's original declination in allowing any damages for this project for our property was based first on an issue that said he couldn't figure out how much we wanted. He couldn't read the PowerPoint presentation. If you look at the first page of the document in front of you, I've summarized that presentation. There's nothing new there. I'm not adding new information, but I am clarifying exactly what was put in that particular PowerPoint presentation. That is for your consideration, and in fact, I stand on those numbers. And in particular, some numbers which respect to each of the mains, lateral 2 and lateral 3. I can't speak to lateral 1, it's not on my property. You just heard from the engineer's office that this project follows the original RIBOB. If you look at the second page, that is their particular document. It was from their presentation on 6/14. That presentation indicated that in 3 areas, this project would not follow the original RIBOB. And they have so delineated those in sections A, B, and C. That's his document, not mine. I would further propose to you or show to you the third page, which was from the 1948 file, which I'm sure the attorney has reviewed. That is the 1948 map of the RIBOV project. And thanks to Otto and Pearl, they carry the name for this project. The project is a dotted line that you see coming up through there. What's missing again from the engineer's documents is the north side of the Todd Street Road. If you look at the dotted line there that goes from east to west or west to east, where the RIBOV project intersects, that's also part of this project. The engineer has somehow forgotten to put that into his project. I don't know how that happened, why it happened. You'll also notice that both on the engineer's drawing, which was page 2, and this drawing, there is no lateral 2. The engineer would have you believe, and the water and soil would have you believe, that you can just wrap lateral 2 into the project because it's no cost and add it to your main. I would suggest strongly to you that if and when it comes time, should you believe you're going to go forward with this project, that when you put your motions together, the motion for lateral 2 must be separate from the motion on the main. There is no statutory provision for including it in the same motion. The next page is a real simple page. It's from the GIS system maintained by the auditor's office. You'll see my yellow property outlined, and you'll see the brown that's there. That is the county drainage maintenance easements in my area. And doggone, this project doesn't fit in that at all. There are no easements. Your GIS people confirm that, and your county puts that out as a public record. Finally, and I may in fact be giving you some hints about things to come, the last page is a summary of critical issues that I believe are in front of this group. As commissioners, I listened to you speak about how the process would work. Part of that discussion was that each time there was a damages request, the person who had damages would make their request, the engineer would rebut, except for us, where the engineer got to go first. And then, as a group, you decided I was second fiddle in that process. That doesn't work, guys. The engineer talks about an established corridor, but he can't define it. You heard him this morning say, I can't define it. I don't know how wide it is. It's because there wasn't one. There is no corridor defined in statute. I'm sure legal can confirm that. The engineer argued originally that there was a gentleman's agreement which would have been respected or reflected on lateral 2. There's nothing there. No one's brought it forward. Even in the written documentation that Mr. Sheets provided in support of this project, he acknowledges that there's no document to support what was done. He may have some bills for what he did, but no one shook hands and said, here's what we're going to do. There are 3 easements on my property. There is a road easement. That was because I own both sides of the road, frankly. There is one for utilities, electric, consolidated electric. And there's one for Delco Water. Those are the only easements on my property. Title company provided that information to me early on. I have copies of that if you need to see it. The auditor was really clear saying, if there are no other current reductions on this property, and he says there haven't been any, then there's been no easements established. So you're cutting new ground, ladies and gentlemen. I have 2 or 3 technical concerns. Part of the engineer's proposal on this project is to remove property that I've placed on my property, to remove stuff. I would suggest to you that that removal and giving that stuff to the successful bidder is property theft, because I get nothing for it. No damages, says the engineer. And if you need to look at that in particular, it is the bridge. And I believe on the first page, it's listed at my estimate, so I don't mislead you. Culvert, fencing, and backfill, $18,500. I bought those culverts, I bought the backfill, and I put them in myself. To replace those costs money. You can't take my stuff away and give it to somebody else. I have not made the technical request for information from Soil and Water, but I do need to make sure that you are aware that any drone footage that was shot for this project or any project that you do must have been done by a licensed drone operator, and the drones must have been registered with the Federal Aviation Administration. Otherwise, that information is bogus and illegal for use. And finally, I've already raised this issue, but I'll raise it again. In order to pass this project in total, you'll need 4 motions. Main, lateral 1, lateral 2, and lateral 3. Lateral 2 cannot be wrapped into a motion on the main, as proposed by Soil and Water. Joyce, is there anything you want to add? I hear you.
Well, sir, that's up to us to recognize, not you, but, okay, thank you, sir.
Thank you.
Anyone have any clarification they wish to make?
Commissioners, again, Rob Riley, Chief Deputy Engineer. I only want to address 2 items that Mr. Bergault raised. The first, the auditor's website with respect to easements that are shown as under drainage maintenance. Bear in mind that drainage layer, that information is specific to those petition projects that are on county maintenance. Those would be the post-1958 projects where there is county maintenance of those projects. The 1948 project, as well as numerous other county petition projects prior to 1958 would not be shown on the auditor's drainage maintenance layers. That's point number 1. Point number 2, with respect to the drone footage, I will point out, we do have two duly licensed drone pilots in our office that have the proper FAA certifications. We do have an FAA registered drone, and so that was the apparatus that was used for the viewing.
Scott, you stood up. Do you have something to add?
No, Rob addressed the drainage maintenance layer.
Thank you. Eric, do you have anything to add from what you've heard? No. Okay. Commissioners, do you have any questions, comments, observations?
I guess I got a question for Rob or Scott. What is the lateral two issue that's being raised? Because my understanding was that it was.
My apologies.
That's all right. I'm ready.
Raise your right hand. I was reading something.
Yes, sir.
Do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Let's pull this out.
All right, let me grab my top.
We don't have a picture, is it?
Oh, because it's the map in front of you.
Yep.
Okay. Well,
You have
now
a
we got
paper
it.
copy and it's
We're
shown
back.
on your.
So
notes.
if you look at the map there that's on your screen, there's a short lateral that would cross from parcel 11 onto parcel 8 that would go through, and it's clearly depicted on the plans. It wasn't put on this exhibit. There was no additional work or scope of work or, I'll say, subdivision of the schedule of assessments required as you would find on lateral 1, lateral 3. That's why it wasn't called out as a separate kind of item within this.
That was my understanding from
Yeah.
earlier
Right.
hearings. So-
Not an oversight is all that has been suggested, just a matter of
Just-
procedure. Wasn't necessary
To do any
to
work.
call that out separately because it's not some distinct unit of work that would require a kind of that additional schedule of assessments.
Okay.
But it's shown clearly on the engineering drawings.
Thank you.
You're welcome.
I saw your hand, but wait, hang on just a second. Thanks, sir. Is there anyone else here who would have anything they think they should need to add to this conversation regarding this? Come forward. Raise your right hand. Do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
And you identify yourself, please?
Stephen L. Sheets, 8907 Todd Street Road. As far as lateral 2, that one has been in on this project since it was started in 48. The original drainage had failed, and it was replaced in 1980. Since then, there's been numerous trees. There's a huge cropping of multi-flower rose type growth. They present no value as far as timber, no value as grazing. However, they do a lot of damage to the drainage. Hundreds and hundreds of roots, and they're right over top of it. And there's already roots in the area. Lateral 2 is just as important as anything. The drainage has been there since 1948. It was just redone in 1980 because the original one failed. And, but that was just an improvement to drainage that's been there forever. Lateral 2 is just as important as anything. If there's a problem coming, that's where it's gonna come soon, from roots. There's no use talking about all the projects in the area that roots in the tile is just damage. It's just a known fact, and it's gonna happen, so it's very important. Thank you for your time. I encourage you to approve it, because it's basically a petition in 48, and they had a need for drainage, and we still do, and in years from now, it'll still be important. It's very important. Thank you.
Thank you. Yes. Do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please identify yourself.
Jim Kistner, 8721 Kilbourne Road. Because this improvement, it's not, we're not putting a new tile in. We're trying to fix what was there. I've owned my property for 20-plus years, and every year it's getting worse and worse. I mean, we're just trying to fix what was there when we bought the place, be able to get rid of the water. Without a good outlet for your water, all your ground, whether you're gonna build a house on it, gonna put hay field in it, or whatever, is useless if it's wet and standing full of water. This tile was repaired, previous to the county, so there is a need for this drainage to drain the properties. You're not supposed to stop surface water drainage. You're not allowed to stop it, so I don't see why anybody's allowed to stop subsurface water. I mean, everybody upstream relies on tiles, every piece of ground, whether you have a house on it or it's just vacant. It relies on tiles to drain it. So I would, hopefully, you consider that, and maybe get this passed so we can drain some water out of places that it's not supposed to be. Thank you.
Thank you. Ms. Burhart, I believe you had your hand up? Please. You've already been sworn in, so.
Thanks again for your consideration. There's no doubt that there is in fact drainage, which is called lateral 2. Lateral 2 on, excuse me for a second. Which is considered lateral 2. If you go back to the first hearing, you'll find that there was in fact a lateral 2 identified in the maps provided by the engineer's office. They just suddenly disappeared for the second hearing. Lateral 2 has no financial impact in terms of being fixed at this point. There's nothing that's been laid out to do with it, but it does exist. It's not part of the main. It's in addition to the main. We don't deny that it's there, but if you're going to put it under maintenance easement and you're going to assess me for part of that, as you are the rest of us, then there's a damage involved. It's not something you walk away from. I again refer you back to statute, which says if you're going to vote on this, main, lateral 1, lateral 2, lateral 3, not main plus lateral 2. Can't do it. Thanks.
Thank you. Any additional comments from either of you? Your talk is the reason I'm assuming there might be something. While we're waiting, Commissioners, do you have any comments?
Let's get a clarification again on lateral 2. It is a
Yes.
little confusing.
Scott
because
Stevens,
it's
again,
not on the map.
Administrator to Delaware SWCD. I think if the commissioners would choose to construct their resolution to approve or deny the project and want to call out lateral 2 specifically, you're certainly free to do that. I don't know that would change, say that the engineering or the I'll say the necessity or the existence of lateral 2 is clearly shown on the engineering plans. If you want to address that separately for everybody's comfort level or to make that open and known in your resolution, do so. Doesn't change any of the other information that would be before you.
It's my impression that lateral 2 is important to the success of this project, correct or incorrect?
In part to the petitioners, yes. I mean, you have a petitioner that has asked for that lateral has been included at the request of the petition. So yes, I'm sure to Mr. Sheets, I think that would be the only landowner that may drain into that. There may be one more. It's certainly important to them, and as a petitioner making the request for a good and sufficient outlet, both surface and subsurface drainage, it was included in the engineering package.
But no work needs to be done on it.
Not currently. There's existing drainage in there, as was stated. It's currently in a condition that would be acceptable. However, that's part of the whole package here, is that the drainage would then go on the drainage maintenance, and at some point in the future, if it would need work, and all drainage undoubtedly will at some point in time, there would be a provision in place to accomplish that.
You want to clarify where lateral 2 is,
Yes, it's on, it goes between,
please?
it'd be easier, like, so there's a short drainage right here, it crosses off of these parcels, it goes across almost right through the number 8. It would drain from this parcel down to the main, about right where the number 8 is.
From the main parcel to
Yeah,
this?
yeah, is that right there?
Okay.
You're real close,
Okay.
yeah. If I may, it sounded like there was some, just to maybe clear up confusion on the notion of the prescriptive easement as that would relate to the old project and what the footprint of the old project would be, and maybe the additional footprint of the construction that would be done, that's proposed currently in today's project as it would relate to the 1948 project. There's nothing inherently different about this project from the 1948 project that would change the kind of the scope of work or the nature of the equipment that would be used or the footprint that it took to construct the 1948 project. Would be no reason to think that today's footprint would be any different. So whatever that easement might have been, or whatever that width of construction was in 1948, I have no reason to believe it would be different today. There's no tangible change in the design or the nature of the drainage there. So it just seemed like we were kind of getting off on a tangent of worrying about some specific footage. There's nothing that, whatever it would have been or whatever it was, I would suggest it would be the same today for the current project as it's proposed. Yep.
Ms. Burkhold, I assume? You had your hand up? Do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Please state your name and your
Joyce
address.
Bergalt, 9032 Todd Street Road. I'm going back to the issue of the width of the easement. Back in 1948 or 49, whenever this was put in, the construction process was much different than what it would be today. And what is designed today has a width that would take between 5 to 8 acres of our land to easement. And I am very concerned about the width of the easement because 160-foot wide easement across our property in 3 different areas splits our property into 5 different segments. My concern is also our ability to cross over those easements and use part of our property, because if we cannot cross and use parts of our property, then we are losing more than half, probably closer to 3/4 of our property use. So I'm concerned about what the meaning is of the easements and the width of the easements, and would like some clarification on that. And fairness. I expect fairness from the commissioners.
Well, I'm sure you'll get fairness. We may be a different perspective, but okay.
I'm sure you will. That's what you're
Thank you.
here for.
Thank you very
Yes.
much.
Yeah, I had a question for Rob, probably. That is, kind of on that point, of wondering just what is the process to clear the main, what width is a permanent width of the main, what's the construction or renovation width and so on. 160 feet sounds pretty wide.
Yeah, and I'd like to defer to Mr. Stevens on the specific width and I guess the construction practices, since his office would be overseeing that work. I can address in general, though, the issue of the easement. I would, I guess state for clarification, what we're talking about is a drainage easement, not a public highway, not some other easement that would preclude the property owner from use of that easement. But the use of the easement has to be compatible with the drainage function. And so putting structures, putting objects, or making alterations within that prescribed easement, if it's not compatible, it is subject to being removed under the maintenance provision of the current law. And so that's fundamentally, I think, what we're talking about. We have drainage easements, the county has drainage easements all over the county. In every case, I would say in every case, the property owner is certainly allowed to and should be allowed to enjoy that property because it is their own. However, their use, again, has to be in such a way that it doesn't interfere with the drainage or the maintenance of that particular drainage feature. So I just wanted to state that for clarification. Hopefully that explanation made sense. I'd be happy to defer to Mr. Hostetler. He's far more eloquent than I am in explaining legal principles. But and then I'd defer to Mr. Stevens on the construction methods.
Thank you.
You're right with you.
Not a problem.
I'm looking at the, is there a hard copy of the engineering plans there, a large roll? Do you have one?
I don't think
Okay,
I,
okay.
I
It's gonna be on that plan, right?
go over this one.
Yeah, go through the plan, do the next page. Somewhere gonna be along that line, there's gonna be a dimension line there. I want to be certain, I'm looking at the construction drawings, I want to be certain of what the construction easement width is on the plan to
Okay.
be accurate in my answer. It's in the notes somewhere.
It's on this page though.
No, it'd be on the, it'd be on the, I'm not sure where he put it. Let me look at those notes again. Right over there, what's that say?
Not very well.
Guess this is what he's saying, this is a year of damage? I gave you this one.
Must be, yeah, 20 years.
I'm gonna keep looking. Our typical construction width easement, and it's on the engineering drawings, I'm not seeing it, 75 feet from top of bank. Moving beyond that, the drainage maintenance easement, that's stipulated by code. It's 25 feet from top of bank, 25 feet from top of bank on each side. But we can go out to the same 75 feet under an emergency condition and would reimburse then for any crop damage or what we might use. But the permanent drainage maintenance easement's 25 feet from top of bank by statute,
Does that mean on each side?
on each side.
So it'd be 50 feet?
50 feet
combined.
total from top of bank. Top width of the channel from top of bank to top of bank, somewhere in the neighborhood of 30 feet. That'll vary a little bit by
because-
depth as the ground kind of undulates and your actually depth of cut would be, you know, it's not a uniform 5 feet over the entire project. Is the one bank may be a little higher than the other, so a stable slope, it's not a perfectly symmetrical arrangement. So you got about 30 foot of top width in the channel itself, and then the permanent drainage maintenance easement's 25 feet from top of bank. construction, current and moving forward under an emergency situation, reimbursed for crop damages would be 75 feet moving forward.
Okay.
I mean,
Mr. Burho, you had your hand up.
We were supplied, as part of this process, a copy of the drawings that he's looking at right now. It would be nice if you guys could see them too. I hope you got them. The construction easement that he's talking about is in fact 75 either side. That's 150 feet. Length of the project that's on my property, if you go back to the documents that I gave you this morning, where it says in the second line, main, lateral 2, lateral 3, approximately 2,867 feet at 75-foot width is over 4 acres of my property. The damage on my property based on current property values is in excess of $55,000 for that move. If he returns it back, which I'm sure he'll tell you he's going to do, to whatever pictures he showed you, then he goes down to 25-foot each side. That's 50 feet instead of 75, so 2/3 of that number is still the damages to me. Guys, I can't get around it. It was without regard for us as a property owner that the engineer initially said no damages for this project. That is, in polite terms, bullhooky. Thanks.
Gary?
Yes. Oh,
Mr. Sheets?
sorry. Just contemplating.
Sure.
Steve Sheets.
Hey, Harvey, swear in.
In 1980, we had that ditch cleaned. It's basically the same plan as now. When Walter Deacon was here, a longtime drainage person in Delaware County, we went to the south end of the property. It's about where the Dale property and the Go property come together. And the ditch, you didn't take out much there. But as we go north, the outlet tiles that was coming in, there was a head wall, and all that was underwater. Dirt was over top of it. We cleaned it to there. All we did was just clean out what was in the ditch, and then the spoil was on the side of the bank and spread out. And all the property was used after that. However, that was a drainage ditch forever, and when it was purchased, it was still a drainage ditch. And you had to know what you was buying. And there was no damages there when we cleaned that, and it didn't restrict the use of the property, but the ditch was always there. It's like anything, you can't build on it or do anything with it. It's a drainage ditch. It's been there forever. It was there when the property was purchased, and folks before that, for 73 years it's been there. And we just cleaned it out, put it back to its original use. If you wanted to ride along it or drive, that wasn't restricted. There was no property taken. Thank you.
Mr. Chairman, one comment here, it seems so much of the contention is just over the definition of the drainage easement. I mean, meaning that, and Rob, maybe you could address this too, the damages that we were told on the main and lateral 3, among them with the main grazing, loss of use of property, another grazing, loss of use of property. Now, you're saying that even though the drainage easement may extend, that would not preclude the property owner from using the property, provided that property owner would not be interrupting the drainage. So, I mean, I guess I'm wondering about the validity of the damages.
Well, I'll start by saying, with respect to the document we received this morning, obviously we have not had a chance to review that, and so we'll be more than happy to do that, but we're going to need a little bit of time to do that. Mm-hmm. With respect to the claim of damages within the, what I will say is the original footprint of the 1948 project, being some width along the bank, plus the bank itself. Mr. Stevens mentioned earlier that the construction methods in that time, while the equipment may have been a little different, the construction methods, I would state were substantially the same as you would today. You're still excavating out material from within a defined corridor. You do need some width of workspace on either side of the ditch to do that, and so it's difficult to imagine that in 1948, 1949, they could have simply built a ditch without extending any width beyond the banks. It's very likely that the width that was used in those days is very similar to the width that we would propose to do under this project. So I guess I would summarize by saying if you have the opinion that there was a maintenance easement prescribed under operation of law due to the fact that the project was built and in continuous operation, then the damage claim for portions within that easement, in our opinion, are not compensable. And so that's the nature of our objection or our recommendation not to award damage claims. If you agree with Mr. Bergalt's claim that there is no easement there, that it is private property and there's absolutely no right for anyone else to come in to have any use of that drainage ditch or either side of that drainage ditch, then I think the correct thing would be to either grant the damage claim or dismiss the petition. I think that's the situation you face because again, the amount being claimed is sizable with respect to the cost of the project, and so we recognize that. Again, with respect to what we received this morning, we haven't had a chance to digest that, and we'd be more than happy to if you choose to continue the hearing. But hopefully that addressed your question,
Do you think
Commissioner.
that would be helpful, having time to digest it or evaluate it, or not?
If there's a desire of your board to continue forward with the project, I certainly would ask for more time to evaluate this, because I just, in looking at this, the 5 pages, I can't ascertain exactly
Sure.
what area those particular objects are in, so.
Sure.
But if,
Well, yeah. That would be a good idea to do. So the engineer's office could evaluate this.
I would also state, Commissioners, certainly you've heard testimony both for and against the project for different reasons. If you feel that there's potential benefit in the project, you should absolutely continue the process, allow us some time to evaluate this, and we'll be more than happy to do that. If obviously we're all busy, and we certainly don't want to expend
Sure.
a great deal of everyone's time, including our own, yours, and the residents, if there is not a desire to move ahead based on what you've heard to date, because I think in evaluating this, we will be very deep into the weeds, so to speak, in terms of what objects are potentially within that original design footprint and construction footprint. So I would just add that. I'm sorry that doesn't
Sure.
give you
No,
a very
that's
specific
helpful.
recommendation. So
Yeah.
thank you.
Yeah.
The main premise that I'm looking at is the cost exceeds the benefits. And I realize this has been dragging on longer than any of us want. But I guess till I get clarity on that, it's hard for me to have an opinion that is fair to all parties involved. And I'd really hate to see a continuation, but I'm not sure we have
Yeah,
much choice.
right.
We need to determine what the costs are, so we can determine whether that's, and again, if the costs exceed the benefits, then then we're obligated to move in that direction. Commissioner Ben, do you have any thoughts?
Yeah, I'm okay with continuing, but I think we need to put a sunset on this thing.
Yeah.
you know, we get a new document with new claims 10 minutes before the hearing and, you know, we obviously don't have time to study it, and the engineer's office needs to react and so on. So I think, I don't know how we would structure it, but if we could require all, assuming we continue it at the next hearing, all material has to be submitted in time for the engineer in Soil and Water to be able to review it and present their
Right.
information.
Right.
I don't know, Eric, your
think
way
Is
in.
that,
You
Eric?
have accepted the claim for consideration, and anything provided today is testimony in support of that claim. These are not new claims, but if you don't have enough information to determine you need some clarification on this testimony and it cannot be provided today, and you are not prepared to rule on the claim, or if you are not prepared to, you wouldn't have to rule on the claim if you were ready to deny the petition. But if you are still not to the point of deciding whether to grant or to deny to the petition, then you need to make a ruling on this claim. So it just comes down to whether you need additional testimony to flesh out the details of the claim. Because the information that all of us received this morning is, correct me if I'm wrong, just trying to summarize or provide clarity to the claim that has already been accepted for consideration.
That is correct.
Okay.
There's nothing new in that document from you today.
So if you need additional information in terms of testimony to explain this information, then you'll need to continue the hearing.
Well, we have your estimate of the cost, but I guess that's your perspective, and I'm not sure.
Well, that's why I asked for clarification.
That's the reason I think we may need a little extra time to digest it and determine whether that is a legitimate number or not.
If I may.
Sure.
We understand and concur that what I put in front of you is an estimate. There are, I believe, and you just looked at, how many pages in that? Is it like 11? The engineer's report is sitting right there, the engineer drawings. It's got the 75-foot here, 25-foot there, all that kind of stuff. It doesn't tell you what the maintenance easement is going to be. It does tell you what to specific detail, what the construction easement's going to be. It doesn't tell you whether I'm going to be able to graze that land. It does tell you they're going to replace a gate. So that's got a lot of detail in it, but apparently that's not in front of anybody. Or some of the questions that are being asked don't seem to make sense to that. We can take, what is the sheet 3 or something that lays out the entire project, hang it in front of you, and you can see 75 foot here, 25 foot here, here's where the bridge goes, here's where the tree that's 3.5 centuries old belongs. Unfortunately, they put it in a different place on the drawings. All that's a lack of clarification. We've been 5 years, and we've never had the opportunity to sit down and say, this is what it's going to be. It's all been speculation. Well, we might go this far, but if we have to go this far, none of that has hit us exact. My wife asked for specifics. I'm asking for specifics. And if you tell me those drawings are the specifics, then my numbers will make a whole lot of sense. And if you tell me that drawing is only an estimate, then I'm with you. I don't know what the number is supposed to be. But I can tell you one thing, there are damages. Without a doubt, there are damages. And the statute calls them out.
Thank you.
Thank you.
Yes, you've got one more. The next step.
Jim Kistner, you know, they're talking about damages, I understand that, but that tile was there when they bought it. It's not new. It was there. It's a drainage ditch. How can you control a drainage ditch? You know, everybody's water has to flow through it. You know, if they didn't know it was there when they bought it, I'm sorry about that, but that tile was there. So there's already an easement there for that tile or for that ditch. You're not asking for anything new. We're just trying to fix what's broke. And you kind of see, this is why we had to go this route. Thank you.
Thank you.
To that gentleman's point, the opinion that I've given you is that when you're trying to, because really what I take away from this is these are the claimed impacts based on the claimant's understanding of the width of the easement to be established for this project. The opinion that I've given you is that in looking at how wide any pre-existing easement is, that what I can tell you with certainty is that you can consider the existing improvement bank to bank to constitute an easement. So if it's just a matter of going through these items one by one, or trying to, as a preliminary matter, determine in your mind what the existing prescriptive easement is for the property, then you can do that today. I'm trying to figure out what additional information you need so I can advise you whether you should continue the hearing or not. But it's your prerogative. If you're not prepared, you don't feel you have sufficient information today or need additional time. But really, the threshold question is, what is the width of the easement? Is there an easement that pre-exists this proceeding? I'm telling you my opinion, but you can
And your opinion is
disregard.
bank to bank.
You can disregard my opinion, you can disregard their opinion, it's your decision. So my understanding is that you need to make a preliminary decision, maybe not a formal order, but at least in your mind, this is what we think exists out there today before this project is approved. What is that easement that's out there, if any? And then you can actually go through these items one by one using the construction plans and the information that's been provided, testimony, and determine what, if any, damages exist. I mean, I would just hate to continue to another day if you can get it done today. That's my point.
Mr. Penn, you've been quiet.
I guess in my mind, I think there is an easement. I mean, I agree with our attorney that there is an easement. And so, yeah, I think that's, I agree with that. But it still raises questions on, okay, what work is to be done within the easement and outside the easement? And that's, I guess, where I'm confused, where I need clarity.
And if that's the case, and you need testimony specific to that point, I would advise you, if we can't do it today, to schedule this for a whatever time, minimum time you need to get that additional information so that we're not kicking this out a long time. So we can come back and finalize this claim, because until we finalize the claim, it sounds like you're not prepared to take any other action. So this claim is the last item, because remember, you have awarded damages to the other claim. So
Yes.
no matter what,
It has
you're gonna
be
have to
redone.
continue this for the recalculation of assessments. And so if we continue this hearing today to another day, you'll make that decision at that next, time that we reconvene, and then you'll have to continue it again. So that's why I'm trying to figure out
Yeah.
if you're just
Well,
time-wise.
one question that I would like answered then would be, what work would be entailed with this? As far as, we're talking about these damages, and again, loss of use of property, which has been contested by the engineer's office, and drainage explained, and we've gone through that. What work would actually cause that damage? Or loss of property? You've already addressed the loss of property.
Yes, Commissioner. So the work that I believe is being claimed would result in a loss would be basically the grading and the operation of equipment within this area that may require removal of certain objects. And again, I apologize because I don't have the background that some of the others in the room have on this project, but I am familiar with the general nature of what's being discussed. I guess the question that we have to address, if your board so desires, is to identify specifically from this list which objects exist within what we would advise, with your board's concurrence and with council's concurrence, within a existing maintenance easement, whether that's bank to bank, whether that's 25 feet from top of bank on either side, whether it's some other number. We would need direction from your board as to how to prepare that evaluation, because some of these objects, my understanding, are within that area, some are not. Some are within the 75-foot area that it has been discussed. And so we would need to differentiate between those at the direction of your board. We're certainly willing to do that. That's an itemized type of effort. I will say, just maybe, if I may, just back up half a step here in talking about the nature of a drainage project like this versus a highway project. With drainage projects that are petitioned by property owners, we have a vested interest. We all have a vested interest in doing these absolutely as efficiently as possible. Obviously, we do that on every project. On drainage projects, just by their very nature, there is some flexibility in where you put that drainage. Moving a ditch 5 feet to miss a tree, moving a tile 10 feet to miss a stump or a shed, something of that sort. You can't do that with a road. A road has to follow a line, or else you're going to send cars flying off the road. With a ditch, a drainage feature, you can do that. And so the nature of our plans for this type of project is different than what we would prepare for a highway improvement. And so while we have a width specified in the plan, the course and path of that easement can be adjusted in the field, and we do that for a reason, because we want to avoid things that we don't absolutely have to interfere with, and to allow some flexibility in when we actually build the project. So your board is well familiar with easements on highway projects. Those are legally the same, but described in a different manner. We have meets and bounds descriptions and a platted limit that can be surveyed to a fraction of an inch, the bounds of that easement. For a drainage project, it's a little bit more nebulous. Legally the same, but the limits can be adjusted. And so the reason we do that is really to protect the property owner's rights, and to make these projects as efficiently as possible, because again, these property owners are the ones paying for these projects specifically. And so where we can make adjustments, we do that. So thank you for indulging me there. That I thought it was helpful to mention that.
Sure. And I guess, can Soil and Water address what they would be doing in this case, or is more work necessary for you to evaluate what you're doing? If one of the gentlemen just stated that this is basically a replacement of what was done.
I think that's an accurate,
Years
the
ago.
drainage is there and has been there.
I mean, if so, then, you know, if it is in fact fixing what's there,
Yes.
that does not seem to tell me that there's a large amount of disruption. If somebody could address that, I
Well,
think, I mean, that would help me.
The disruption that would be there, the excavating equipment setting adjacent to the ditch, the sediment coming out of the ditch, the conveying or spreading of the sediment, all the things that go into creating the project as it would be historically, would be largely the same. Very similar equipment would be used today. All that disturbance would be within the prescriptive easement, as I understand it from your council's description of that. Any activities within the prescriptive easement at that point should, I guess in my mind, be reasonably expected by that landowner. That easement exists there by statute, by legal precedent. And with the belief that we're going to work within that prescriptive easement, that negates then the notion that what are seen as damages, that they may be seen as damages, but they wouldn't be compensable at that point, would be my understanding of what's been said. I mean,
I don't want anyone to focus too squarely on the word damages, because what we're really talking about is compensation and damages. What in the eminent domain world we refer to as just compensation. So it's way too easy to think about damages in terms of being physically damaged by some activity. But
Okay.
what the board is actually trying to, or needs to determine, is not just damages to property. It's what does the compensation do the property owner? And compensation would be including not just those physical components, but also the actual land that is taken. When you have land that is not subject to an easement, and you take an easement on it, that can be calculated to acreage, and acreage has a value. And when we take easements for other projects, whether they be sewer or roads, we value those easements based on the per acre value of the property and some percentage of use. I don't know what appropriate percentage of use for a drainage easement would be, but it's certainly approaching somewhere between 50 and 90%, but not 100% of the value. So those are the types of issues you need to determine in terms of compensation. Anything that is already subject to an easement would not receive full per acre value because it's already subject to an easement. What I'm telling you is that on this particular property, the only thing that I can tell you with any certainty is that there is a public improvement on this property. It was petitioned for by owners in the 1940s, and the board at that time approved it, and it became a public water course. And even before the change in the drainage laws, a owner could petition the county to come and maintain that improvement. After 1957, that became incumbent upon the board as a mandate to actually maintain those improvements. But what is clear is that there is an easement out there. You just need to figure out what the width is. And once you determine what you think the width of the existing prescriptive easement is, then you can say, okay, well, this is how much beyond that we're going to be taking as a part of this project. Assign a value to it, assign a percentage to it, and then that's the compensation for the actual land to be used for this project. Then you go in and talk about damages. And so it's compensation
Yeah,
and
yeah.
damages.
Yeah.
Improvements on the property, I assume that what, and Mr. Burgall or Mrs. Burgall can elaborate on this, I assume that these listed items they're claiming are improvements within the easement that they're claiming are being taken as a part of the project. That's why I'm saying, start with a determination as to what the width of the existing easement is, then figure out what in your mind, the scope of the new easement would be, and then you've got these list of improvements on top of the land value to go through and say, okay, well, that one's in the prescriptive easement, so there's no viable right to compensation for that item. If it's within the new easement and outside of the existing easement, then you need to determine whether it's actually being taken and whether there's any value to it. So it is I'm not going to say that it's not a labor-intensive analysis, but you only need to go through that if you need to decide the claim as a part
If we're
of
gonna
deciding
go
the
ahead with the
overall
claim.
petition. So those are decisions that you'll have to make. What information do you need? What decisions need to be made and when? I don't want you to focus too much on how this equipment is going to go out and physically damage the property, because it's compensation and damages both.
Okay.
He had his hand up first.
We've been asking for 5 years. for the clarification that you're asking for right now. We've not received it. We asked back before Thanksgiving to have Soil and Water come out and plot specifically where this project was going to be on our property. They couldn't do it because they had people on vacation and hunting season was coming up. Okay. So this spring I asked, would you come out and do it? And they said, nope, we don't do that until it's been approved. That's what we faced for the last 5 years. We faced original representation from Soil and Water says we can't graze any of the property that we touch. Can't do it. A couple years ago, we met with Soil and Water and some other people. They said, oh yeah, you can graze it. Tell us what kind of grass you want on it. We don't have clarification. That's all we're asking for. I respect your comments, Counselor. I believe you're right on target. I believe you addressed this group and told them that bank to bank is where he believes you stand on easement, in effect. That means anything beyond the banks is potential for consideration for damages. If you want, we can unroll this set of plans over here and show you what the engineer has said is going to be the construction easement. If you won't do that, I'm sure they can unroll them for you. You can see it. If you look carefully at their documents, which I shared again with you this morning, you can see that they're not following all of the previous project. In fact, in 3 places, they move away from there. It's unfortunate that the people with lateral 2 haven't brought the issue of land being taken from them and compensatable. And it's unfortunate that Pam, Rice, and husband have not done the same. Because in both those lateral 1 and lateral 3, the new path does not follow the old path entirely. And they agree to that. They put that on the table. And in fact, part of part of the main is being redirected on this one too. So the concept of corridor, I don't know where that comes from. Look at their maps. Look at their own stuff. I'm not bringing you new stuff. I'm bringing you their stuff back at you. Listen to council. There are some issues here that need to be taken care of. Finally, my wife and I had a discussion, sitting here. I'm more than willing to do what hasn't happened in the last 5 years, and that's sit down with the engineer and look at those plans and exactly tell us and decide what's going to be there. Well, we're more than willing to do that. No one picked up the phone to make that question. Hey, what's going on? We've asked people to do it. Not going to happen. Well, we might go here, we might go there. We'll go over there. We'll look at the tree. Tell us what it's going to be. That's all. Thank you.
Okay, guys, your thoughts? This one obviously is complicated. We want to be fair, and fair, I realize the eyes of the beholder. I heard that there's some dispute about this 25 feet or not, and I think it's very hard for the commission, I'm giving my perspective, Richard. It's pretty hard for the commissioners to make an evaluation when we don't have clarity about where that is. So, is it possible for there to be a continuation and come up with a number that on our next, when we get back together, we can, because the cost, in my view, it's going to come down to the cost of the project exceed the benefits. But until I have a clear understanding what that cost is, it's hard for me to make to evaluate it. And I'm speaking for Gary Merrill. I don't want this to be drawn out any longer either. By the same token, I want to get it right. And I'm not sure I know what right is right now, to be very candid with you. Those are my thoughts, so your guys' comment.
What about the, as Mr. Bogalt, said with, I've got to ask Scott this, I think. Scott, what about, the feasibility, as Mr. Bogart said, then, you know, he hasn't gotten certain questions answered, and I'm not sure, you know, what's going on there, but is it possible for you to give him more definitive answers when you go out to his property?
We've met with Mr. Borgalt, myself, and my staff, and county engineer staff numerous times over the last 5 years or so. We're certainly happy to try again to help bring the clarity, but I'm unfortunately, I don't know that we're going to be able to give the answers to him that are being sought, and the disconnect would remain. Rob and I were, Rob, if you'd like to.
Yes. Commissioners, what we can do in response to Mr. Bergalt's request is to actually delineate, I would propose to basically establish 3 lines, basically delineate the existing edge of bank, 25 feet from the edge of bank and 75 feet from the edge of the bank. Show that on the plan specifically in relation to what items Mr. Bergalt has raised in his claim for damages and compensation, and then report that back to you either at or prior to the next, if you wish to continue, we can certainly do that, because I think what you're asking is entirely reasonable for clarification on specifics. I will say again, that's again on a drainage petition project, all of this effort we will be expending does take time, and these are billable costs, unfortunately, because we don't pay for drainage petitions out of motor and gas funds. And so these costs do add to the project cost. I'm not trying to hit anyone on this project with more cost. No one wants to pay that, but the fact of the matter is this does take time. And so I think what I might have heard Mr. Hostetler say is if you do feel there's merit to this project, based on what you've already heard, it's a good idea to do that. If you don't think there's merit to this project, based on what you've heard already, I don't think that's time well spent. And so
Okay.
I realize that puts you in a very difficult position right now, and I don't mean to do that, but that's, again, we're very happy to do that. There is some time that would be required to do that, so.
So let's take it.
yeah,
Is there merit to the project?
Yeah, I do think there is merit to the
Yeah, I do.
project.
So
I do
I
too.
think we
Yeah.
all agree that is
Yeah.
the case. The question becomes, what is
What's
the
the cost?
cost?
Mhm.
And until I know that, and I believe I'm hearing
Yeah.
that from my fellow commissioners, it's hard to make the evaluation to move forward. So in your idea of doing it bank to bank, 25 feet, and the third step, I think it helps us, because we're ultimately going to have to make a determination, but knowing those differential, again, back to the cost and benefit. Does that make sense?
Complete sense, sir. Yes. Yes.
So then, yes, I would,
So is there a way we can continue this, though, and do it all at the next meeting?
yeah.
No, I don't think so, because the costs have to be reworked.
You will have to make a ruling on this claim, and then you'll have to continue again
Right.
to have the assessments recalculated, because you've already awarded a claim. And if you recall, last time,
Right.
you didn't order them to redo the assessments because you hadn't ruled on this claim yet. So there will need to at least be 2 more
I got you.
sessions where this is addressed.
I think I knew that, I'm just hopeful.
I do want to, I want to make sure that the board gives specific instructions so that we don't have to redo it. And by we, I mean them, not me. That your opinion, for purposes of this analysis, is that the existing easement is from one bank of the existing improvement to the other, and not anything in addition to that, because as you've heard from Mr. Riley, the engineer's position is similar to what it would be for a prescriptive easement for roadways, in that it's not just the physical width of pavement for the road, it's something in addition to that. And that's a very fact-dependent determination, but I just want to make sure that you're clear to them, so that when they do this document, they can say, okay, well, this is what we're going to count as the existing easement, and everything outside of that is subject to compensation and damages potentially.
Now, just to clarify to our council, you are saying that it is, the present easement is just bank to bank, which means
I want
Like-
to be,
like it doesn't extend further than each bank above, are you saying it doesn't, the easements don't extend beyond what the current drainage is?
I'm telling you that the only thing I can give you in terms of a definitive opinion is that it is at least from bank to bank.
When you say bank, what bank to what bank?
This is an open ditch through this,
Okay,
portion
so
of the
you're
property.
saying like a ditch, okay, it's an open ditch, so it just extends, yeah.
and if
from
I'm wrong about that,
Both sides of the ditch,
There,
just saying, yeah.
Scott Stevens, Administrator, Delaware SWCD again. There would be elements of the project that would be tile. And the tile, the subsurface drain, doesn't necessarily always parallel where the open drainage would be. So there's elements of both.
So it would extend beyond bank to bank, is that what you're
Yes.
saying?
In some
Yes,
areas.
some areas there wouldn't be a
Some
bank
areas.
because
Yeah.
it's subsurface drainage only.
Yeah.
And I would look to the statutes of what that easement would be, or what, footage we would attach to that.
Okay. Yeah. Yeah, I think that would be helpful.
Well,
So first, we have to decide if we're,
I'm gonna, this is not an easy one. What we're hearing here is 25 feet on either side roughly. You're saying bank to bank. So the question becomes, are we asking them to do both and we'll evaluate later? Can we do both and then make that evaluation later? Do we need to definitively determine that today?
I think you should be asking the engineer what the basis for the 25 feet is, because that is based on current law.
Not the law in existence.
That's right. So if you want to, it's not an either or, there could be an option C. The extent of the existing improvement as it was established in 1948 is my opinion that has a prescriptive easement that goes along with it. It's very easy to say when you have an open ditch what that is. It's more difficult when you have subsurface involved. And I'm not really sure how to advise you on that. But I don't want you to think that it's what I'm telling you in terms of my opinion, what is clear versus 25 feet from the bank. Because it could be something less than that. Somewhere between 25 feet and the current boundaries.
So it could be 25 feet.
Could be, if that's what would be reasonably necessary to maintain that improvement. Because what I don't want to get lost is that just because in the 1950s, the legislature mandated that the county maintain these improvements, before that, there was a procedure for the county to be petitioned to go maintain it. So it was at least contemplated, when this improvement was established, that maintenance would be a regular activity on this improvement. It's not that these were just built and never maintained. There was a procedure to maintain them. And so it makes sense to me that there would be some additional feet from the existing improvement for purposes of maintaining it. And that would also be a part of the prescriptive easement. When you think about the law on prescriptive easements, with respect to roads, which is when we normally deal with it, it's never just the pavement. It's just the pavement is an obvious starting point. So that is something that I think you need to decide today, so that they can be properly directed to prepare this additional information so that you don't need to continue it an additional time.
And I think Rob has addressed that by saying there's the basic bank-to-bank, and then there's the need for additional footage on either side of it for maintenance. And that makes sense to me.
So we're asking Rob and Soil and Water to basically give us an estimate based on that criteria.
If there are,
So is that,
So what I would propose is we would tabulate in essence, in kind of 3 columns, which objects that are being claimed are within
Within
the
those
bank-to-bank
parameters.
or within the immediate footprint of the tile. And I'm not exactly sure exactly what width we can assume there, because an 8-inch tile or 12-inch tile, it's completely impractical and if not impossible to construct or maintain that in a vertical manner right over the pipe. You have to have some width. So we'll have to come up with what we feel, but we will do that.
Okay.
And then again, a 25-foot maintenance area, which would be consistent with the 1957-58 law. And to Eric's point, I think the 25 feet didn't come out of nowhere. That wasn't just, hey, let's just make it 25 feet. Clearly, there was a long history of counties maintaining ditches before 1957. And so there was a reasonable allowance or in the interest of making a uniform, making it understandable to the public, to the owners, that width was chosen. That width is representative of the type of equipment and the methods of work that would be necessary to dip out and maintain that ditch or replace the tile. And so 25 feet is not unreasonable, I guess I would say that. Could it be less? Maybe, but I'm not sure we're going to ever be in a position to be able to determine whether it could be less definitively. So again, my proposal.
Sounds as though we don't need the 75, though.
Well, the relevance of 75 feet is for construction, basically construction, any area beyond 25 feet that we would have to disturb outside that 25. So we will certainly do that as well.
Machinery in, or-
But that would be in your estimate as well.
That will be
Okay, all
itemized,
right.
yes.
Are we all on the
Yeah.
same page?
yeah.
So it appears that we're going to have a continuance for the purpose of giving the county engineer and the soil and water an opportunity based on that 25-foot definition. So is that agreeable?
Is the 25, yeah. I mean, do you want to go 75? That's what you said.
We will do that as well. We'll basically
Okay, so
draw
it is
3 lines
all
on
3.
on either side.
And I would ask the clerk to close the hearing.
We
The-
can't close, we're
This is gonna
continuing.
take-
Just so we're clear, Commissioner Lewis, the 75 feet, what we're talking about is a temporary construction easement.
Yes.
On any type
Oh,
of
okay.
project, those go away when the project is done.
Oh,
So
good,
it's just
okay.
rendering.
I
Oh,
want to
gotcha.
be very clear that my opinion is not that that would be included as a prescriptive easement.
Okay,
I'm willing to, I would tell you that it's reasonable for you to determine that the 25-foot permanent easement is a good benchmark, because that is consistent with present practice. And if the testimony from the engineer is that that would have been the practice at the time that this was created, I won't tell you that sounds reasonable to me.
okay.
I was giving my opinion just on what I could definitively tell you. But I can also, on the other side, definitively tell you that it's not 75 feet on either side.
Okay,
That's not reasonable in my opinion.
So,
okay,
Rob, we're all on the same page?
Yes, sir.
yeah.
A date.
Engineer Riley, would the end of September be enough time for this work, or do you need me to look further out than that?
So I think I would defer to Scott, but I think we're gonna need some more time, probably after the leaves are off the tree, and so we can go back out.
If we can do this by simply pulling tape, measuring without survey equipment, we could, the September, maybe into October would be sufficient. But if we're gonna actually put transit on it, we would preferably have the leaves off the trees.
Be prepared to do that.
Okay.
Yeah, we want to make sure when you come back.
Right.
Yeah,
There won't be another
last.
meeting.
That's why I was clarifying to what degree that when we say establish or survey that, what's that?
I would suggest maybe the first part of December.
So what's the
First part
timeframe?
of December, if that would be agreeable.
What's that?
The first part of December would allow us enough time, once the vegetation is
And we'll
thinned
come
out.
back, you'll come back on that date with,
That
Yes.
was Monday, December 6th?
Good by me.
I'm okay on that date.
Yeah, that's
they're
fine.
quicker than I am. Looks good to me.
And it, yeah. 10 a.m.?
10 a.m.? Okay.
Yeah, I'm fine. So this, we're continuing to December, what was that date, 5th?
December 6th.
December 6th at 10 o'clock a.m.
I
Let me
see.
read the resolution. Resolution number 21-715, setting date and time for the continuation of the final hearing for the consideration of the Rybov number 620 improvement petition project to December 6th, 2021 at 10 a.m.
So moved.
Second.
Motion made and seconded, discussion.
Vote on motion 21-715. Mrs. Lewis?
Aye.
Mr. Merrill?
Aye.
Mr. Benton?
Aye.
Very well.
Okay.
Mr. Merrill, question?
Sure. Let us get out of this and you can, what's your question? Go ahead.
Come to the mic, please.
Information's going to be prepared.
Come to the mic, please.
Sorry.
Yeah.
First of all, thank you for the considerations. I understand information will be prepared for presentation to you on the 6th. As the affected property owner, I would like to have a copy of that information in sufficient time to review it prior to the presentation, so that I'm not having to ask you to delay another meeting. And counsel is shaking his head yes.
Well, that's the
that would be
expectation.
appropriate.
I think that we've already made that clear. that will
Well,
occur.
I would hope that you would direct them to do that. Otherwise, we'll be faced with the same situation of getting information and having to
I
push
think
it
there's
off.
an understanding by everybody, okay?
When could we expect to see that? A week in
Thank
advance?
you.
Yeah, go ahead.
We need to adjourn.
I would,
Yes, we need to
Yeah.
adjourn.
I would like to have that more than a week in
I'll-
advance, please.
I'll
Okay,
move,
thank you, sir.
yeah.
Adjourn.
If it's without